Hi, Max here with FrizWoods, and I'm going to answer some of the questions that you might have about bail reviews here in Maryland. First of all, when we talk about a bail review, we're talking about a legal proceeding at which you or the defendant's release conditions are set. First and foremost, I need to differentiate between the two common venues for a bail review. Venue is where it takes place. First of all, here in Maryland, we have a commissioner system. Commissioners issue charging documents as well as conduct initial appearances, and these often happen at a detention center here in Maryland. So, if you are arrested and the warrant came from a commissioner and it is a district court case, then you will likely be brought before a commissioner for your first initial appearance. An attorney can represent you at that appearance and bail can be set. Some jurisdictions even allow pretrial release conditions, and all jurisdictions allow for a commissioner to set a money bond. So, the second venue for a bail review is before a judge, and these often take place in the district court, although in certain cases which have been filed in the circuit court, your bail review may be before a circuit court judge. What options does a commissioner and a judge have? Generally speaking, here in Maryland, there are a few common terms you're going to hear when it comes to bail. First and foremost, the goal for all bail reviews is for a defendant to be given what's called personal recognizance, or for short, PR. Personal recognizance is a bail condition in which a person is released with absolutely no restriction, or perhaps some restriction, but there's no money that's required to be posted, no GPS monitor required to be worn, no drug testing or checking in or anything like that. The second type of bail that we often see are what are called unsecured bonds. An unsecured bond is essentially a promise that if you do fail to appear at court, then you will actually create a debt for yourself that the state of Maryland can collect against you. The other type of bond, which is what most people are used to, is called a secured bond. A secured bond is when you, a family member, or a bondsman physically comes in and posts the bond. It's usually set in dollars, and some commissioners and judges will set a percentage of the bail a person needs to post. If there's no percentage set and a corporation is authorized to post the bond, generally speaking, you will contact a bondsman here in the state of Maryland and give them a fee of usually around up to 10% of the actual amount. They'll then post the full amount. You won't get that 10% back. The incentive to the bondsman is that when you do appear, they get all their money back. So far, we have personal recognizance, unsecured bonds, secured bonds, and now we have a new type of bond that very frequently happens here in Maryland, and that is known as forms of pretrial release. Pretrial release is an alternative to the old money-based bond system. If you're given a pretrial release bond, you could be placed on one of several different levels, depending on the jurisdiction, administered likely by the jail or a pretrial services unit for the sheriff's department or police department for the county in which you're brought before a judge in. If you're placed on some form of pretrial release, you may have to check in with those pretrial release authorized agents. You may have to wear a GPS monitor. You could be required to do drug tests. Other types of conditions that you might have placed upon you, whether you're on pretrial release, personal recognizance, or some form of money bail, is likely no contact with the state's witnesses and the victims, and probably to stay away from the area where it occurred. Now, what happens if you go through your commissioner bail review and you're held? Well, then you'll see a judge on the next available court date. So say, for example, Mike is arrested on Saturday for drunken disorderly, and on Saturday night, he sees a commissioner who denies him bail. On Monday, if that's an open day for court, Mike would probably be placed on the bail review docket for a court. He could be represented by the same attorney that represented him at a commissioner, or be provided an attorney by the public defender. The third option is Mike could represent himself, but obviously I always recommend against doing that. What does a judge consider and a commissioner consider when setting bail? They're tasked with creating the least onerous conditions to ensure that a person appears at court and does not present a danger to the community or themselves. Generally speaking, if you are placed on pretrial services, you may not be much of a danger to another person who perhaps lives 45 minutes away if you're placed on a GPS monitor, and absent some prior showings of failing to appear at court, it may be argued that you're not likely to fail to appear, especially if you have contacts in the state or community ties. What do I do if I've been denied bail? You may be seeking what is called a second, perhaps maybe it's even your third bail review. And generally speaking, an attorney can file a motion requesting to be heard by a court. The court has discretion to hear that, and some courts will apply arbitrary standards like the need for a change in circumstances. Perhaps your strongest argument for a new bail review might be if certain charges against you are dropped, your trial date is set inordinately far out, or your attorney discovers new evidence. If you or someone you love is detained here in Maryland and needs an attorney for a bail review, give us a call. I'm sure we can help. Thanks.